warning you, we did live streaming and recording momentarily.
Good morning. Welcome to the First District Court of Appeals. Alrighty, so we have 5 cases on the docket this morning. 4 are scheduled to argue. 1 has submitted on the briefs. The first case that we have is State of Ohio versus Dimitri Smith, case number C230224. If attorneys can please identify themselves in the readiness to proceed.
Good morning, Your Honor. Michelle Berry on behalf of Dimitri Smith.
Your Honor, Keith Sauter from the State Court.
Thank you. Next case we have is State of Ohio versus Jamon Terry, case number C230383. Attorneys can identify themselves in their readiness to proceed.
Yes, Your Honor. Elizabeth Conklin on behalf of Mr. Perry.
Good morning.
Keith Sauter.
Okay, you're a frequent flyer today. The third case we have is a case named State of Ohio versus Blake Anthony Leonard, case number C230589. This case has submitted on the briefs. Fourth case, State of Ohio versus Alex Lawson, case number C230633. If attorneys can identify themselves.
Good morning, Your Honor. Krista Giesky on behalf of Alex Nelson. Ready to proceed?
Good morning.
Good morning, John Hill on behalf of the State of Ohio. We're ready to proceed.
Thank you. Good morning. And the last case we have is Daryl Swan et al. Versus Villas Condominium Unit Owners Association et al. Case number C230517. Good morning. If attorneys can identify themselves at readiness to proceed, yes?
Yes, Jesse Jackson Jr. for
So your first name is?
Jesse J-E-S-S-E.
Okay. Okay. And?
Good morning, Your Honor. Adela Brevis on behalf of the defendants.
Okay, thank you. All righty. You can come forward when you're ready.
Good morning, Your
Good
Honors.
morning.
I would like to reserve 3 minutes for rebuttal, if I may. And before the time starts, I would just wanted to address a preliminary issue that I just discussed with Mr. Sauter.
Okay.
There is an exhibit that's admitted into evidence. It states Exhibit 9, which is Dimitri Smith's police interview. It's a video recording. And there are transcripts that go along with that. In volume 8 of the transcripts at page 269 and 270, there's a discussion about the transcripts of that video. And the parties agree at that point that the transcripts are erroneous. There's many mistakes in it. And so the parties agree that the transcripts are not being admitted, just the recording. But I noticed that as I was preparing for this and reviewing everything, those transcripts are actually part of the record that this court probably received, because when I went to view the evidence, those transcripts were in there along with,
So when you say the parties agreed that the transcript is not part of the record, they
and were
agreed?
not admitted.
Okay, so this is pursuant to an agreement that was made at the trial court level? This is an agreement where?
In the trial court level, at the close of defense case,
Okay.
the state was admitting.
So
state's
we'll be
exhibit-
governed by the record then?
Okay,
with
so I
regard
just want to
that.
make sure
Okay,
that this court knew that those transcripts were not to be considered.
all right.
With that being covered, like I said, if I could reserve 3 minutes for rebuttal.
You got it.
Michelle Berry on behalf of Dimitri Smith, Your Honors. This morning, of course, the briefing in this case involves 4 assignments of error. I'd like to focus on assignments of error 1 and 2, especially assignment of error 1, because in explaining assignment of error 2, I will hit the high points of assignment of error. In explaining assignment of error 1, I will hit the high points of assignment of error 2, which is a very crucial error in the fact that the trial court did not even consider the presumption of self-defense at all, which is part of the state's burden. So that's already a fatal error right there. Backing up to assignment of error 1, in which I will explain why that presumption applies in this case, there was an egregious evidentiary error in this case. What happened was, in the state's case in chief, the state presented part of Dimitri's statement to the police from the detective's narrative, but they literally spliced a sentence in half and removed the crucial words in the middle of that sentence and gave it a whole different meaning. So the full statement was, Dimitri stated the passenger was about to pull, and then he observed the handle of a pistol on the passenger, so he fired 3 shots. That's the full statement. What was admitted was Dimitri stated the passenger was about to pull, so he fired 3 shots. Now, obviously, the full statement gives a completely different meaning to what happened than what was admitted. And the problem is, this occurred in the state's case in chief, and when the Rule 29 motion was argued, the state actually exploited this issue and gave a misleading characterization of what the evidence actually was.
But I guess I'm a little confused on this argument because I thought that on cross-examination, defense counsel got out that when questioned about what he was going to pull, the officer said a weapon, or the detective said a weapon.
Well, yeah, he said he presumed he was about to pull a weapon, and that's a very good point, because in the state's brief in response, they brought out that point as well, and you could take that 2 ways. One way is, that's a concession of the most important point of this whole appeal. If this court takes that concession and says, yes, we believe that a weapon was about to be pulled and it was a gun, it was a firearm that could be used instantaneously to kill somebody that's point blank range like Dimitri was, then the presumption of self-defense applies, and as a matter of law, the state should have lost that Rule 29 motion, because the only disputed point then is conceded in the record, that Carter was pulling a gun on Dimitri.
So so you're saying the state concedes that this information was brought out in the state's case in chief, that about to pull meant about to pull a weapon.
Yeah, and more importantly, not just a weapon, but a gun. Because if you think about it, a weapon, was that a knife, a baseball bat, like something that can't be...
I guess defense
yeah.
counsel didn't elaborate and say.
Well, they weren't allowed. They weren't,
Well,
like...
they didn't follow up on that question, did they?
Um,
What do you mean by weapon? You mean firearm?
Right, I think you're right. One important thing that happened was when the Rule 29 was being argued, the state, like I said, exploited that issue and said, well, he was about to pull something, we don't know what, and really highlighted that point and said, well, there's really no evidence that there was a gun with Mr. Carter until 36 seconds later. But that's much different than when he's 12 inches away from him pulling a gun out. So if this court takes it that that is a concession, that a weapon was about to be pulled and it was a gun that could do harm, deadly harm from that range instantaneously, then that's huge. That's a huge concession that triggers right there the presumption of self-defense is applicable. And as a matter of law, the state, not only should the trial court have considered the presumption of self-defense because it applied and it's a statutory mandate, but the state loses it because the four elements of the presumption of defense are force is used, the person using force is lawfully in the vehicle, and the person against whom force is being used is either has entered or is about to enter.
Let me
that
ask you,
vehicle.
what evidence is there that the fellow that got shot was entering or about to enter the vehicle?
The actual pulling of the gun.
That
Now,
means you're entering, I mean.
about
I
to
thought-
enter.
I thought the testimony was he didn't pull a gun, he saw it in his waistband.
I'm sorry, what?
I thought your client said he saw the weapon in the waistband as opposed to, it wasn't being brandished, at least I didn't see that in the transcript. The
Well,
fellow-
he did say about to pulling, upping the butt. These are the different terms that he used. So that is, I would say, one split seconds of your life, when your life hangs in the balance
Don't
by
you have
split
to kind of
seconds.
pull on the door handle or stick your hand inside? I know the windows were up, but wouldn't there have to be some evidence that that person was actually trying to get into the car as opposed to just walking behind the car?
Well, he wasn't just walking behind. He was literally inches from where Dimitri was sitting inside the passenger seat, beginning to pull a gun out, which Dimitri saw, observed. And that is when Dimitri pulled his weapon and fired the shots. And everything that we have in the law to look at, case law, common law, and I would call it a common sense approach to this that the federal courts, primarily the Sixth Circuit, has used, points to a gun entering a home, but in Ohio, self-defense law includes a vehicle, so I'll say vehicle. A bullet entering that protected space of vehicle as counting as an entry. And I can point you to some of that case law, which is primarily discussed in the reply. It's discussed in the briefing, but more elaborated in the reply.
Let me ask you another question. Was a Rule 29 made at the close of all the evidence?
At both, at the close of the state's case and the close of all evidence.
And this was a bench trial, and the judge had, at that point, had heard all the evidence, right?
At the close of the state's case?
No, at the close of, not the state's, but at
At
the
the
end
close
of the
of all
trial.
evidence?
All evidence.
He had, so I'm going to address 2 points. Well, let me
Okay.
speak to that first. The point in time of the close of the state's case is crucial, because even though by the close of all evidence, the full statement had come in, the reason why the close of the state's case is the crucial point in time is because the case should not have proceeded beyond that. It shouldn't have moved on to Dimitri's testimony, which he did a great job. Like I pointed out in the brief, he actually was consistent throughout his testimony and in his statement.
But the trial
But-
judge said he didn't believe him, right?
Correct. And those credibility determinations that the trial court ultimately used against him occurred because of the defense's case. The case should not have even reached that point. At the close of the state's case, the presumption of self-defense already applied, and according to Ohio law, which this court affirmed last summer in State v. Robertson, the presumption of self-defense puts an additional burden of proof on the state, not a burden of persuasion, but a burden of proof.
So you're arguing here the Castle Doctrine, right?
Yes.
And the argument is that if somebody even threatens to point a gun into a vehicle, then the Castle Doctrine would apply.
The act of beginning to pull a gun would count as an attempt to enter. And there's case law and common law arguments to back that up.
So what is your, because I guess I missed a case in Ohio that extended the Castle Doctrine that far. So what is the case you're relying on?
There's a first district case, State v. Cuthbertson, that specifically cites a Hornbook on this issue. that explains that firing a gun into a house counts as an entry. So the extension of
Something's
that.
going into the house, though. The bullet's going into the house.
Well, but here the law says an unlawful entry or an attempt to unlawfully enter. So if you are pulling a gun on somebody inches
I
away,
understand your argument. What is our standard of review?
in this case, it's de novo. Typically, it would be abuse of discretion. It's de novo because when there's been a complete misconstruction of the law, de novo review kicks in. I am blanking on the case that points that out, but it is cited in the brief under a subsection called standard of review. So I apologize that I can't think of the case
I'm
name.
not sure that the state would agree with you, but we'll be talking about that in a few
Okay.
minutes.
Can you give us, besides the Cuthbertson case, do you have other cases?
Yeah, and this is elaborated more in the reply. I think Cuthbertson is the only one cited in the main brief, in the principal brief.
Okay.
In the reply, this whole subject is elaborated on much more. Santana out of the second district, it's a much more benign situation, but that court discusses that even rocks being thrown onto property counts as a trespass. So you have to think about the implications.
Is that a self-defense case?
No, it's talking about unlawful entries onto property and trespassing and what that means. Also very important, because dating back hundreds of years, the common law supported this principle as well, where.
You have about a
it was-
minute left.
Okay, thank
Okay.
you. It was widely established that if a gun entered a property, that counted as an entry, and this is discussed in the reply as well. And
But what about any case, I mean, I think you have a very interesting argument, but I was just looking for any cases that specifically talk about this pointing a gun into a car or a house and the castle doctrine applying.
no, not since all these changes in the self-defense law. As you know, it's changed a lot
Yeah.
in the past decade. So I can say in the past years, since there's been many changes in Ohio self-defense law, there's not a specific case like this one. But if you look back at the whole history of how entries onto property have been treated, this situation always falls within it. A bullet entering property counts as an entry onto that property. And
Is this going to be a plain error review, though? I mean, was there a proper objection below on this presumption?
Yeah, this would be plain error, because and I did raise ineffective assistance on this point too, because when the court failed to even consider the presumption of self-defense, everyone just went along with it. So that is correct.
So
And-
then going back to my question about standard of review, under plain error, the Supreme Court has sort of tightened up plain error a little bit, and it has to be obvious. So how is it obvious?
Well, it's obvious because, I'd just like to hammer home this point about why this attempt to shoot a gun at Dimitri counts as an entry. The other 3 points about the presumption of defense are really not in dispute. Obviously, there was force. Obviously, he was lawfully in the car. Again, don't forget that point about the state's concession. If the officer presuming that that was a weapon is taken by this court to mean that Carter was armed and was pulling out a weapon, a gun, then there's really no dispute here. But in any event, it's obvious because if you think about, and I'd urge you to go through the reply discussing the common law on this point. If you're sitting in front of a window of your house watching TV and you turn around and there's somebody holding a gun outside the window to your head, that person is obviously much more dangerous to you than somebody who is, in that moment, than somebody who is just walking through your unlocked door.
This is about the error being obvious, not about the facts of the case being obvious.
Yeah, so I'm being a little long-winded of trying to address your point, but the reason it's obvious is because once it's accepted that there is a presumption of self-defense that applies, and I think that the facts in the law line up to have that presumption applied here. the case should have ended at that point. And if you look at the court's arguments when he's convicting Dimitri as to why he is actually convicting him, it's because he doesn't believe his testimony. He finds him not credible. The case should not have reached that point. And the issue is there's unrefuted evidence in the record. The state did nothing. The state didn't call Carter or Stubblefield to say, no, Carter wasn't armed. The state didn't call the neighbor, Dimitri's neighbor, who identified these men, and which is the reason why Dimitri recognized them when they pulled up and say, no, those aren't the same two people that fired gunshots at his house earlier that
So I
night.
think what you're arguing is that because the facts were obvious, the error was obvious. Is that in essence what your argument is?
Well, there's two parts. I think it's plain that the presumption of self-defense should apply. And once that presumption is applied, it's obvious that there is, not only did, setting aside the point that no one even discussed the presumption of self-defense at that point, there is absolutely no evidence in the record at that point in time of the state refuting it whatsoever. They've put on no affirmative evidence. And the law is very clear that to rebut a presumption that's applied, the state has to affirmatively present evidence. There just simply
All
isn't
right,
any.
thank you, thank you.
Thanks.
Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, I think what we have to keep in mind here is that this was a bench trial, and two things come to mind. Number one is that there's a presumption that the court followed the law. Number two is that we have an insight into what the court's reasoning was in this case. In order for the presumption to arise, there has to be some quantum of proof or quantum of evidence to indicate that the victim of the case was the aggressor. And in this case, number one, there was no indication, no direct evidence or even indirect evidence that he was about to enter the car in any way. And second of all,
Well, I think the argument here is more about the gun.
Right.
Because then, then when with the
Yeah.
gun, then you get into the entry of the vehicle.
Right, but even if we make that leap, Your Honor, the salient point here is that the trial court simply didn't believe that that was the case. The trial court said in announcing its verdict, and it doesn't really matter if it's at the close of the state's case or the close of the case or the close of evidence. I did not believe that the defendant, number one, knew the victim or recognized him. I did not believe the victim was the aggressor. I did not believe that the victim had a gun at the time of the incident. So whatever foundational evidence was offered to give rise to the presumption simply wasn't credible in the eyes of the trial court. Unrefuted does not mean credible. The trial court's free to believe or disbelieve any evidence that comes before it. And I think in this case, the trial court made clear that it simply didn't believe the foundational evidence that would have given rise to presumption if believed.
What do you think about the argument, though, that because there's no specific case on this in Ohio, that the Castle Doctrine would apply if, in fact, the court did believe that the victim had a gun?
I don't think Cuthbertson helps us because that was a sufficiency of the evidence case, talking about entering the screen door of a house being sufficient evidence to indicate breaking and entering. The closest thing I see here is Reimer, out of this court, 2021 Ohio 2908. It was not directly on point, but this court held the defense counsel was not deficient for failing to request a Castle Doctrine instruction when the melee or whatever confrontation there was happened outside the car. And I think that that absent a clear indication that the victim was going to enter the car in this case, I think that's what we have. I don't think we have any. I don't think we have any entry. I don't think we have any attempted entry.
Well, I guess the entry would be the pointing the gun and a bullet potentially entering.
I guess, Your Honor.
Yeah.
And that's the argument. But once again, if the trial court didn't even believe that the gun was present at that point, I think that's moot. And I think that's what we have here. We have a clear indication on the part of the trial court that whatever foundational evidence would have supported the presumption under the Castle Doctrine simply wasn't credible in this case. So no matter how you slice it, I think the trial court was correct. Unless the court has questions, I have nothing to add.
What's our standard of review?
I think your standard of review in this case is, would be abuse of discretion. I'm sorry, it would be plain error because there was no, the opportunity for the trial court to at least enunciate the standard for the presumption was never raised. The trial court was never given the opportunity to explicitly address that or to answer whatever objection there might have been on that score. So I think that, I think we're stuck with a plain error standard.
And I want to make sure I understand what you're saying. So with regard to whether self-defense should have been considered, it hinges on the determination of credibility in this case?
I think it does, and I think this court has indicated in many cases that a self-defense case often does come down to a matter of credibility. And here, when we have the explicit statement of the court that it didn't find a certain piece of evidence or a certain section of the evidence to be credible, I think we're stuck with that determination. And as I said before, unrefuted does not equal credible. The trial court was free to completely disregard whatever indication there was that the evidence supporting the presumption that it was not credible.
At the close of the state case, can you please just clarify what was it that the bench found not to be credible?
Well, it didn't announce anything at the close of the state's case. It announced it when it was announcing its general verdict that it didn't believe that the victim had a gun. It didn't believe that the victim was the aggressor. So no matter what evidence would have happened after the close of the state's case, the trial court had already made that determination. It simply didn't find the evidence to be credible that the victim was the aggressor here, and I think that's fatal to the argument on appeal.
Thank you.
Thank you.
Your Honors, I'd just like to point out that the state entirely focused on the wrong point in time. Again, those credibility determinations pointed to in the record by the trial court all happened after the close of the state's case. There's that's all based on Dimitri's testimony, which obviously happened in the defense case. At the close of the state's case, there is nothing to be found not credible. The only thing that happened at that point, and I want to touch on the standard of review because I think errors 1 and 2 have different standards of review. At that point in time, this egregious evidentiary error had occurred, which is the court allowed the state to splice this sentence from the detective's narrative to give it a completely wrong meaning, a completely different meaning than what had actually happened. If the entire statement
So
had
it's
been
your position that at the close of the state's case, there's no credibility determination, and at that point, there was evidence with regard to the firearm, and that there was sufficient for self-defense to be considered for the remainder of the case?
Exactly. This evidentiary issue is a very clear-cut one. There's arguments that 106 was satisfied, but there's stronger arguments based on the constitutionality that trump Rule 106 in any event, that clearly the full statement should have come in. If the state was splicing the sentence to remove the crucial words from the middle, the defense should have, at that point in time in the case in chief, been able to admit that full sentence to give the full meaning. And at that point in time, at the close of the state's case, there was that, not only would that have been in the record, but the state offered nothing to refute that. So the only thing that would have been in the record, and again, credibility determinations would not have had anything to do with it at this point. The only thing that would have been in the record is that Carter started to pull out a gun on Dimitri, which is what triggered him to fire shots. And lo and behold, he was armed because after Dimitri was able to flee into the hotel, Carter started firing shots at him again when he peeked out to see if anyone was still there. The state simply offered nothing to refute these points at the close of the state's case. Carter and Stubblefield didn't testify to say that Carter wasn't armed. They never asked for help from police like an innocent victim would if he all of a sudden pulled a gun on and started shooting and Carter hadn't been armed. All the ways that the state could have refuted this simply didn't happen.
But the judge still, I mean, if the judge were to, I mean, he watched the video, and he would still have to evaluate your client's credibility based on whether he believed what your client, his version of the events, right?
Well, that's the problem. The video, this is a crucial point. I'm so glad you said that. The video was not admitted at that point. The video was only admitted at the close of the defense case. So the only thing at all.
Testimony of the officer?
Yes, and that spliced written narrative.
But then there was the cross-examination of the officer where he said, pull a weapon.
Right, correct.
That part,
Correct,
yeah.
that was on cross. But at that time, it had already been ruled on that, and they had a lengthy sidebar on this. I think it's pages 162 to 165 in the transcript of why the court was sustaining the state's objection and not allowing the defense to get in those crucial words in the middle of the sentence. So again, that's an egregious, obvious evidentiary error. That should have been in the record. The state didn't refute it. The presumption of self-defense applies, and it should have been considered, plain and simple. And the fact that it wasn't is plain error, because that is a statutory mandate. It's not just statutory, it's constitutional. That is an actual additional burden of proof on the state. We're talking about 2901.05B2, which is...
Attorney Berry, I want to clarify the record, okay? I want to make sure I understand it correctly. The video itself, was it played for the bench?
No, it was not. It was admitted at the close of defense case.
I understood that,
Yeah,
but it was not played.
No, it was not.
Okay. Did the trial court render a decision immediately, or was there any pause after the close of the case before the trial court rendered a decision?
You know, Your Honor, I cannot specifically recall. I know that there was no pause between the close of the state's case and going into the defense case. I believe that there was no pause. I could be wrong. There may have been an overnight, but there was not there wasn't like a week pause in the trial before he entered a verdict. There may have been an overnight. I don't want to say the wrong thing, and I can't remember.
Okay. I mean, the record should reflect it one way or the
Yeah.
other. Okay.
Yeah, I just don't remember. I do know that the state was able to begin a rebuttal witness, which was immediately cut off, and then that was the close of the whole case. And the court may have recessed overnight, but I just don't recall.
It's all right. No worries.
If
If you want to wrap up, I'll give
Yes.
you a few seconds.
Thank
to
you very
reflect.
much.
Okay. All right. All right, thank you. We'll take the case under submission, issue a timely decision. Wish you both a wonderful afternoon. Enjoy the weather before it gets too hot again. State of Ohio versus Jamon Terry. Good morning.
Good morning, Your Honors. Will it please the court? Elizabeth Conkin on behalf of the appellant, Jamon Terry. Similar to the previous case.
Would you like to reserve time?
Oh, sorry.
That's okay.
Let's go 8 and 7.
All right.
Something different.
So you're going to reserve 8?
No, I'm
You're going to
sorry,
argue
beginning-
8?
beginning
Okay.
and reserve 7.
And you're going to reserve 7?
We're going to do something different.
All righty. Well, we'll see how it all works out for you.
Unfortunately, we won't know for a few months.
You have an audience watching. We have all our interns
I know.
here. And
Don't ever do
We even have
that.
someone that's on his way to law school here.
Similar to the case before, we've argued for assignments of error. I'm going to focus on 2, even though I think all of them are meritorious. The first 2 do impact the third and the fourth, which are manifest weight and sufficiency of evidence. This case really turns on the improper admission of the DoorDash email. There was,
And just to clarify, was the email admitted or just discussion about the email?
just the discussion
Okay.
about the email, what the email said.
Okay.
And there's no dispute that this is hearsay. The minute someone starts to say, well, DoorDash sent me an email saying there's an objection, the court sustains the objection, the prosecutor says, okay, without telling me what the email said, what did you do next? The problem is, even without the disclosure of the content of the DoorDash email, the fact that Mr. Trotta was allowed to testify over objection, well, I took the information from the DoorDash email and I looked online for the Facebook page of Mr. Terry. This obviates the ruling precluding Mr. Trotta from testifying that DoorDash had identified Mr. Terry as the person who used his credit card unlawfully to order food on DoorDash.
Well, wasn't it the DoorDash account versus someone that had used the credit card illegally? They said it's this guy's account. They didn't say you used your card was used, but he said it. I mean, they could have used it on my account, and then my picture would come up.
Well, and that's obviously, the argument. But the problem is, it immediately validates all the evidence that came after that, which is, I looked online, I found Jamon Terry's face, and that's the guy.
Okay, so this has to be an out-of-court statement that is used to prove the truth of the matter asserted.
Correct.
What is the truth of the matter asserted here?
That Mr. Terry used unlawfully the credit card that had been stolen from Mr. Trotta the night of the robbery, just hours after the robbery.
But that would just be receiving stolen property then. I mean, if I used your client or Mr. Trotta's credit card.
Yes, except that the
then-
timing of it seems unlikely, given that this is in the middle of the morning. It's not like days passed where he could have purchased the credit card. The timing here, the fact that the armed burglary, the home invasion occurred, and within just a few hours, the stolen credit card is used to make a purchase through DoorDash, through Mr. Terry's DoorDash account. I agree that, you could have said that maybe someone in his household used the credit card, but it still connects Mr. Terry to this crime.
Are you saying, so this is a confrontation clause argument?
Yes.
How is this even testimonial?
This is similar to the Ricks case.
Which that case was information provided to an investigator, a police
Absolutely.
officer.
But that's what Mr. Trotta testified to doing. He was performing his own investigation. He was trying to determine whether there was evidence that would help the police solve this case.
But aren't we looking at the speaker's idea of, we're looking at the expectation of the DoorDash rep and whether they expect that what they say is going to be used in some sort of prosecution.
Yes, Mr. Trotta, the information that he received from DoorDash was only after going through many steps required by DoorDash to establish why he should be entitled to information about someone else's DoorDash account. And Mr. Trotta explained, I was held up at gunpoint, my credit cards were stolen, I received information from my credit card of an unauthorized use, specifically using it to purchase food through DoorDash, and that's why I'm asking for this information. So DoorDash knew that this wasn't just I'm checking on my account to see if someone else has used it. It was, I am trying to get information to help the police investigate this crime and determine who it was who robbed me.
And everything you just said is in the record
Yes.
as far as his testimony about how he got DoorDash to release that information.
At some point.
Okay.
Wasn't it also offered for a permissible non-hearsay purpose?
Well, first of all, the objection was sustained.
Well, I know it was sustained, and then what happens is that it goes on, and then, but at some point, there's also, it's tenuous whether there was actually an objection, but I'm not even going to get into that part of it, okay? Because that gets us to plain error. I don't think you
Well,
want us at
I
plain
think
error.
it's-
So,
Harmless error, plain error. And I mentioned this in the brief. I think it's harmless error because you don't have to keep objecting once the court has sustained an objection where the basis is obvious. I think that the basis was obvious here.
let's get back to my question, if you
Okay.
don't mind, which is, wasn't it offered for a permissible non-hearsay purpose?
There was never a response. The objection was made, it was sustained immediately without response from the state. So there was never any proffer.
Right, but then, I understand, but now we're going to possibly get to plain error. So we can get to plain error, you can answer my question. Because you're answering it in such a way that's getting us to plain error. Because you're right, it was objected, it was sustained.
Yes.
But then there was more questioning, more answers.
Right.
Answers that were violative of the objection that was sustained.
Correct.
But at some point, that objection is not renewed.
And my position is, under 103A, you don't have to renew it. It's
Okay.
evidence rule 103A. When the objection has already been sustained and the reason is understood as to what the basis of that objection was from the circumstances of the testimony and the the quickness with which the court ruled on the objection without asking for a basis, that there is no affirmative duty for the attorney to keep objecting over and over and over again.
Well, the witness is answering and giving information that the attorney is desirous of not being heard by the trier of fact, and yet allowing for the trier of fact to hear it.
Well, I think, we frequently make that argument that there was ineffective assistance of counsel, and the typical response is, well, it was trial strategy because they didn't want to point out to the jury, again, what the witness had just said.
I'm looking at an excerpt here. It looks like they did object again. I
Yes.
see that there was a objection, the court sustained it. The state gets into without saying what DoorDash told you. There's an exchange, and then he says, well, the name that was given to me, I searched on Facebook, objection.
And then it's raised again on cross-examination.
Well, what he says what the defense asked on cross-examination, did you tell your friends who you thought had robbed you? And instead of just saying yes or no, he says, yes, I told them the DoorDash had identified Mr. Terry as the person who stole my credit card, and then I looked Mr. Terry up on Facebook, and I identified him as the person who held the
It
gun.
seems like that's the most fatal part of really synthesizing it really clearly for the trier of fact, was the response during cross-examination.
Absolutely. And my point is, this is the third time that Mr. Trotta, it's not like this is the first time he testified. This case was tried once. He testified. The DoorDash information didn't come in the first trial. He made every effort to get around the judge's ruling preventing him from testifying by trying to get that information in 3 times. He finally got it in the third time in a non-responsive answer to the defense counsel's cross-examination. And rather than get it out there in front of the jury again, the defense attorney just decided to let it go.
I think it sounds to me like your real difficulty with this is that there was information, that's what I'm trying to understand what was in the record, that DoorDash said that Mr. Terry used his own DoorDash account, but the victim's credit card.
Correct.
And I'm trying to find it where in the record it says that, because there's an answer, well, I got an email from DoorDash saying that the account objection, I'm going to sustain the objection. Without saying what DoorDash told you, you got information from DoorDash. Correct. What was the information? Did you do an investigation? So really what seems to have come in was simply that DoorDash gave him a name
Yes.
without more information about,
Well,
because you're trying to say that it linked Mr. Terry to this robbery, and it might have a little bit, but it was really just about how he got this name to search on Facebook.
Well, but it links Mr. Terry to the robbery just like the Rayvon Ragland's fingerprints on the cell phone link him to the robbery. And that's what the state relied on when they were asking the resource officer, were Jamon Terry and Rayvon Ragland friends in high school? Oh, yes, they hung out together all the time. And then arguing that because Rayvon Ragland's fingerprints were on the cell phones and they were friends years before in high school, they must have done this robbery together. So it's the same argument. You can't have it, they can't have it both ways. You can't argue that, well, the cell phone fingerprints really only established that he touched them at some point, doesn't necessarily mean that he was there at the time of the robbery. But that's the inference.
How should the state have gotten this info? Because, clearly the jury is going to get confused about why he's searching for your client on Facebook.
Yes.
So how should the state have?
Well, you do what you always do. You issue subpoenas or you issue a search warrant. You do what, they had 3 years to get this information lawfully and to get the information.
So you're saying the only way the state could have had this victim testify about how he got to your client's name is if they would have subpoenaed DoorDash?
No, I don't think he ever gets to testify to Joe DeMonterey's name.
Oh, he
I don't
would never
think
get
it's-
there.
Under Rick's, even when it's made to a police officer, the police officer's not allowed to give information that he receives that triggers his investigative course if the information links the defendant to the crime. It doesn't say committed the crime, links him to the crime, and this links him to the
So
crime.
you're saying that whole piece of,
Should not have come
I
in.
searched Facebook, I found him on Facebook, it looked like the guy that robbed me, all of that stuff
He
shouldn't have
can,
come
no, he
in?
can testify that he looked on Facebook, but the catalyst for doing that
Should have not come
should
in.
not have come in because what it allowed the jury to do in and I say this in our argument, is disregard everything else that calls into question the ability of these witnesses to identify Jamon Terry as the shooter or as the gunman and not be able to identify the other guy who is unarmed and therefore not a threat, who goes around from person to person collecting their property. And
So let me ask you this, what if the testimony had been simply, based on information, after my conversation with DoorDash, I went online, and I found the picture, and I recognized him, that's the
Yes.
same person that came to the
that's
door.
fine.
So
There's-
it's
because
funny because to me, that seems like a fuzzy version of the same. Ultimately, the trier of fact is going to deduce from that there was sufficient information to find Mr. Terry.
Well, maybe
And-
not, but we don't know. And I think part of the problem is having someone tell you, I found the guy that had
And that really gets to Judge Krause's question, which is like, this was, in essence, explaining the actions that Mr. Trotta had taken.
Yes, except that it totally links Mr. Terry to the crime.
And didn't a second witness identify your client as the person that robbed him? I thought there was another gentleman in
Oh, there are other witnesses,
Which
but
is
they all
independent.
were told by Mr. Trotta, here's the guy who robbed us.
So
He sent them a
He showed
picture.
that, okay.
So every identification is tainted.
So that would have come in anyway, right? When the
Yes, but you
the
would have
defense
had
would have
more,
wanted that.
you would have had a better chance of convincing the jury that these identifications are unreliable because you wouldn't have had the DoorDash information linking him to the credit cards.
All right, thank you so much for your argument.
Thank you.
Good morning, and may it please the court. Ms. Conkin says that there's no dispute that there's a hearsay problem in this case, but I would say there's absolutely no hearsay problem in this case. What the state was trying to prove was not that Jamon Terry used this credit card illegally. That wasn't on the table at all. The only thing it was trying to demonstrate was that that's the starting point, the absolute starting point of the investigation that Matthew Trotta undertook. And I struggle to find anything wrong with what Mr. Trotta did in
So
this
it's your
case.
position that it was offered for permissible non-hearsay purpose?
Absolutely, Your Honor. It was offered to demonstrate the identity of this person. It was offered to demonstrate the starting point of this investigation. And it's unfortunate for Mr. Terry that it linked him to the crime, but that's just the way it is. I mean, we can't.
Now,
we can't.
what Mrs. Conkin finds objectionable is that it links Mr. Terry to the crime. How do you respond to that?
Well, that's unfortunate that on his part, but that doesn't make it a violation of Rick's. There's no police involvement in this case until a lot further down the road. And in any event, the only thing that was testified to on direct examination was, I got this name. This is a name that was provided to me. There's no hearsay problem with that. There would be nothing testimonial about DoorDash. Even if it was linked to saying what DoorDash told him, there wouldn't be any hearsay problem with that because it's not what they're trying to prove. You're trying to prove the starting point of this investigation and how he tracked this guy down.
Because what linked him to the crime was ultimately looking on Facebook and recognizing him from the robbery.
Right, exactly.
Yeah.
Exactly. And Matthew Trotta didn't do anything improper here. DoorDash didn't do anything improper, and the trial court didn't do anything improper in letting this limited testimony about what the starting point of Matthew Trotta's investigation was. I see nothing in the record on direct that would indicate that Matthew Trotta was permitted to say to DoorDash, is this a person who stole my credit card, or is it? Otherwise, the things that Matthew Trotta testified to merely indicated that he got a name from DoorDash. There's
So
nothing in the record.
even if we were to agree with you, I call it the Blevins test. You know what I'm talking about?
I do not, Your Honor.
And that's when you have a permissible non-hearsay purpose, that it can still be so prejudicial that the probative value is outweighed by the prejudicial effect.
Well, I would argue that even under the Blevins test, that certainly is not met here. It's very probative of who committed this crime, and the limited purpose for which it was offered would definitely not be so prejudicial or outlandish as to create an improper inference in the mind of the trier of fact. So I think in this case, it was fairly innocuous what Matthew Trotta said on direct examination. And the fact that it was brought out on cross is unfortunate for the defense, but they didn't ask that the response that Matthew Trotta made be stricken from the testimony or otherwise disregarded by the trier of fact. So I think that we do have a situation where there's no error, but if there were error, it would be invited.
Do you agree that this is testimonial?
I do not agree it's testimony, Your Honor. There's no, it's not offered for the truth of the matter asserted, and that's the essence of a confrontation clause problem.
Well, it has to be testimonial and offered for the truth.
Exactly.
Great.
And I think it's neither, because there was no indication that there was something in the mind of the DoorDash representative that, hey, Matthew Trotta is going to take this information and go on Facebook to determine that this guy committed an aggravated robbery. It's too tenuous, and I don't think we can infer a testimonial intent just from the record that we have here.
Now, you're saying that the cross-examination, that response was invited error?
Well, Your Honor, yeah, I do, because they got, well, it was invited error if the answer that the defense counsel got was not responsive. It was incumbent upon counsel at that point to say, hey, wait a minute, this is non-responsive, ask that it be stricken, and ask that the jury be informed not to consider this evidence. So to the extent that it could have been remedied at the trial court level, yes, I think it was invited error. Unless the court has any questions, I just see no problem with this case at all.
Okay, why don't you go ahead and address the second assignment of error? And I know that it was touched upon.
Yeah. The Raglan assignment of error?
Right.
Yeah, I understand. I recognize and acknowledge the limitations of the probative value of the Raglan evidence, but it does establish some link of Mr. Terry to the crime. I think it's probative in this case. I don't think there was it wasn't so inflammatory as to create a misimpression in the mind of the trier of fact about the facts of this case. Again,
Can we talk about standard of review on that? Because your briefs differ on that.
on that, I think that there was no 403 objection about the probative value versus the likelihood of inflaming the jury. So I think it's probably plain error, but I think under any standard of review, it's a kind of call the trial court makes all the time.
It's typically an abuse of discretion, right?
Typically would be, yeah, and in this case, this is the kind of call that the court makes all the time. Yeah, there's some probative value to this, and it's a classic kind of weighing that a trial court does all the time, and it's something that the appellate courts have traditionally been loath to interfere with, and I don't think there's any reason to do so in this case.
All right, thank you.
Thank you.
First first, with regard to whether there's a confrontation clause issue with regard to the DoorDash information, I cite in the brief the United States Supreme Court case of Clark, where they specifically refused to address whether the confrontation clause statements to a person other than law enforcement are excluded from consideration. So the fact that there is no case law that says you can't consider the confrontation clause challenge in a situation like this supports the position that it is up for consideration here, especially considering it's not, to distinguish it from maybe perhaps someone just calling, oh, I don't recognize this charge, I'm going to call up my credit card company and see what's going on and maybe I can get it reversed, to the situation here, which is by his own testimony, Trotta says, I was going to conduct my own investigation and see if I could figure out who did this to us. So he's acting.
You know,
even,
let me ask you a question.
That's
Okay,
fine.
so what's the difference if Trotta called the police and said, hey, somebody used my credit card in DoorDash, and DoorDash went ahead and subpoenaed that information and then found out through Facebook that you found your client's picture and then did a photo array and everybody picked him out. What's the difference?
Well, the difference is the police aren't telling the witnesses, this is the guy that robbed you. And that's what Trotta did with that information. The police went, I'm sorry.
I'm sorry, I keep interrupting.
No, that's
Did
fine.
the defense attorney argue that it was insufficient or suggestive identification by everybody? So the jury was aware of everything you just discussed, and the jury was aware that it could have been suggestive, but apparently disregarded that.
Well, right, because they had the DoorDash verification that Jamon Terry was somehow connected to this crime. That one piece of information, that DoorDash identified this man as the person who used my stolen credit cards, was tainted the rest of the case. It allowed the jury to believe this information, because DoorDash doesn't have a dog in this fight. There's no reason for them to provide inaccurate information in the minds of the jury. And so, obviously, all of these identifications must be valid, because Mr. Terry has already been linked to the crime through DoorDash. If they didn't have this information, then the argument that it's unlikely that they would be able to identify Mr. Terry as the offender when they couldn't identify Mr. Ragland, and we all know that the prosecution was arguing that it was Mr. Ragland that was the accomplice. They said
His fingerprint was on one of the phones, right?
his fingerprints were on the cell phones that were found blocks away from the house. Rayvon Ragland was. His picture was in those second set of photos that the victim or the victims and the witnesses were shown. They were not able to identify him. Why were they not able to identify him, but they could identify Mr. Terry? Because of the DoorDash information that gave credibility to those identifications. If you look at the testimony regarding the police, the investigator who showed up, the first on the scene, these people weren't able to give any information that would have allowed the police to identify who did this. They were taller black man, shorter black man, older black man, younger black man, light skin, dark skin. No descriptive identification of who these people were, and that's why they weren't able to identify Rayvon Ragland as the accomplice, because no one said, this is the guy, like Mr. Trotta did with Mr. Terry. And the problem with the inadmissible evidence coming in is, whether you look at this as plain error or harmless error, the error affected the outcome of the trial. And we know this because the DoorDash information didn't come in the first trial, and it was a hung jury. So with that, I would ask that you sustain the assignments of error and vacate the convictions and send this back for a new trial.
Thank you.
Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon. Stacey Lawson.
Good morning, Your Honors. I would like to reserve 3 minutes for rebuttal, please.
Okay.
May it please the court, Mr. Hill. As you know, this case involves a challenge to a conviction for complicity to burglary. The first issue I want to touch on is venue. That is our first assignment of error. So venue is, as you know, not an element of an offense, but something that must be proven beyond a reasonable doubt in every case. Here, the issue is subject to plain error review because no one raised that trial. However, Ohio law does provide that lack of venue constitutes plain error, warranting reversal and discharge.
But now, with the new Supreme Court decision, it needs to be obvious. So how is it obvious in this case?
I don't know, because venue is linked to, I agree that that is a qualification on the plain error standard now, but I think because venue is linked to jurisdiction, that it maybe lies outside of that restriction even. Venue contemplates...
Rather than arguing how it doesn't, why don't you answer my question as to how it's obvious?
Because if, under the Ohio Constitution, it must be in the county, and if no one testifies that this act took place in the county, then that is clearly outside the applicable law, providing for venue, that venue is proper in this jurisdiction.
Help me understand, because I thought there was testimony that this took place in Hamilton County. I thought that the victim, when he was testifying about his residence, he was asked, "Where do you live, sir?" And he said his address, and they asked, "Here in Hamilton County?" And he said, "Yes, sir."
He did.
Okay.
But the thing is, and I'm trying not to use house numbers to protect him.
I didn't want to use house
Right,
numbers either.
Right. He did say a named address on, I can even avoid saying a street with a W,
Yeah.
in Hamilton County, Ohio. And I think that everyone was kind of asleep at the wheel and glossed over. And then later in his testimony and in Ruberg's, all of the testimony says that this took place on a Home City Avenue. Sorry, I said that one, but,
On a different street?
yes. Yes.
So is there like some assumption that this victim moved or something? Or
I don't know.
What are we doing?
I don't know.
Okay.
Again, I think it was asleep at the wheel. I think it's a very standard. Everyone just asked, it was the first question asked of the first witness. He said this other address really quick. I think no one paid attention to that. And it is a different and distinct address from both the Bill of Particulars, which is the home city, and that is testified to the home city through the rest of the testimony. So that first address is never mentioned again, and that was the only address to which the county was linked.
Didn't Ruberg testify he lived in Sailor Park, across the street from the victim?
He
I mean,
did.
is Sailor Park good enough?
No. So if you look at the Foreman case out of the Ohio Supreme Court, that is cited in our brief, and I looked back when I was just sitting there. The statute we cited references jurisdiction, and then the Ohio Supreme Court, Article 1, Section 10, has been construed by the Foreman Court to mean county. I'm not sure why county is tantamount above. I'm sure there's a reason. Tantamount above city and state, but has to be the county in which the offense occurred. So if you look at other cases cited in a brief, 2 out of this court, one is Sullivan and especially Gardner. Gardner, there was testimony that the incident took place at a restaurant at 1412 Vine, across from the Red Horse Bar, at the corner next to Kroger, and defendant lived at 28 East 13th Street around the corner from Kroger. All of that was not enough because none of those were attached to Hamilton County, Ohio. And the way that it was described by the panel is those facts were not sufficiently unique to permit the conclusion that the restaurant was in Hamilton County, Ohio, the place it occurred at. Same here. Again, I'll refrain from street names. There were 2 mentioned that were not so special. Everybody knows that those are in Hamilton County and that it's even something that you could judicially notice. So under Gardner, under Foreman, Sullivan, we cited a few more cases in our briefs. Even though it might seem counterintuitive, it does need to be county. And it's kind of similar to the Ronisha Robinson case out of this court where there was one element. That was a criminal damaging case. It's not on point factually, but one element of criminal damaging is lack of consent. You're like, of course, no one's going to say, here, damage my car. But the panel held, rightly so, that is an element. That is something that has to be proven.
I'm trying to understand what you're arguing from the record, though.
Yeah.
Okay, so you're saying there was a different address that the victim said this occurred at?
Yep.
And then later, he was asked, where do you live?
That was first.
Okay, so he's first said where he lived, and he gave an address, and he said that address is in Hamilton County. And then later, he said this happened at a different address? That's what you're saying the record shows?
Yes, later, all the testimony from O'Neill and Ruberg all references that Home City Street. And then
A different street.
And then a third street that's not.
Now, are they referencing a street of where they saw the car sitting in this case, or the address of the victim, where the robbery took place?
So the Home City is where Ruberg says he lives, across the street from the victim. And then the car was on a side street, another named side street, and proceeded closer to.
Okay, a
Home City.
different side street. Okay,
Right.
all right.
But I think it's a corner, but the map that was shown to Ruberg wasn't admitted into evidence, so I'm not really sure. But I picture it as possibly being an intersection of those two.
Okay.
And I have a question that you may
Sure.
not know the answer to, and that's okay, because the record will speak for itself.
Okay.
There were firearms that are involved in this case. I'm assuming that they were taken into evidence by the state.
They were not in the, you mean, were they seized? I don't think they were ever located, if I remember correctly.
Okay.
I know for sure they were not with the exhibits custodian, but if memory serves, I believe they were never tracked down.
Okay, so there's no evidence or paperwork attached to evidence in this case?
I don't believe so. Maybe Mr. Hill can correct me if I'm wrong, but I'm about 90% sure that
It's
the
okay. Yeah.
firearms were never recovered.
All right, I appreciate that.
Okay. So, really, I won't belabor the point, just that this is an element that has to be proven. I think it was an oversight. Everyone was kind of asleep at the wheel because it's so easy to prove. It's usually the first question. Was this in Hamilton County? Yes, the end.
Yeah,
And-
the kink here, and I did notice that, is that the address that the victim testified to as to where he resided is different than the bill of particulars and so on.
Right, and then case law saying, the Foreman, Sullivan, Gardner, Lehman, all saying that street names are not enough. City alone is not enough. It's the county that's the crux under the Ohio Constitution. The next thing that I will address is, under the second assignment of error, we challenged the sufficiency of the evidence for the actus reus element in two issues. And I actually like the second issue the best. So the second issue, and it's kind of a technical argument, but I think it's clean, that the burglary was complete at the latest when Brandon, that is the defendant's brother, at the latest when he exited the O'Neill house, but really at the earliest when he entered. So Revised Code 291112A2, the burglary statute, says that it prohibits someone from entering an occupied structure by force or stealth.
I understand your argument, and I actually did some research on that.
Okay.
So help me understand this, because someone can aid and abet by providing the getaway vehicle.
Okay.
And obviously, in providing the getaway vehicle, the burglary has been completed at that time, because the person is exiting with the property.
Yes.
So how do I reconcile that?
So I would answer that question with the question, were those burglary cases? That it was aiding, complicity liability, that's the Lexis search I would do. Is it complicity liability with burglary and not theft? Because theft is not complete till the person is out and deprives, like in that Circuit City case, the Ratkovich case. The theft is technically complete when the person leaves. The burglary happens when the person enters. So my first question would be to narrow that down to, are those all burglary cases? If so, this might be a nuance they didn't properly address, but the second answer to that is that the getaway car thing is a murky area where sometimes that can be proof of aiding and abetting. And we would submit that in this case, that given all the other circumstances, that it is not enough to be considered a getaway car. And for that, the Ratkovich case out of the 7th District, it's cited in our brief, it is particularly helpful. So in Ratkovich, the defendant drove her son to Circuit City. He went inside, she stayed, I believe, idling in the very first spot in her Jeep in front of the store. He comes out with electronics running, jumps in the car, says, "Go, I stole some stuff," and she drives off like, and the record there, the court said it didn't support complicity liability because even though he got in the car with something, that knowledge that someone enters a car with stolen goods doesn't mean that the alleged complicit party shared in the actus reus or the intent, the mens rea.
So that's a different argument than your
It is.
completion argument.
It is, but that's part of why I would argue that to dispel the getaway driver notion in this case as well, because she was pegged as a getaway driver. You're clearly in the first spot idling, and it doesn't look good. But same here. While it might not look good, there has to be a bit more connecting them. And I think that back to our first actus reus sufficiency argument, really the crux of
Which
this.
is the actus reus that's missing here?
So yes, they have to either have, it's a long list of words, but aided, abetted, conspired to procure the person to commit that offense, right, the burglary. And there is no evidence that Alex did anything but pick his brother up when he was done cutting grass. It's going to say that,
While holding a rifle that was in a case that would not have any connection to mowing grass.
right, and that's what his brother came out with. But under the
Right.
case law we cited,
And wouldn't that rifle be obvious? I mean, it isn't like he had an envelope in his pocket.
it is, but under the case law we cited in the brief that merely having knowledge that someone else committed a crime, and again, Ratkovich is the one that comes to mind. They said that while that's an exercise, it's poor in judgment. Imagine it's someone's blood immediate relative getting in a car after having done something stupid. And it's poor judgment not to have what kicked him out, made him walk home, but he didn't. It might not have been the smartest move, but it doesn't necessarily make him complicit. It doesn't mean he joined in that act or that intent.
Again, I think it brings us all the way back to the getaway vehicle. So he's providing the means of moving his brother with the rifle away from the home from which it was taken.
And at most, that fits neatly into accessory after the fact or obstructing justice. So the obstructing justice statute, 292132A1, says that no person with the purpose to hinder discovery, apprehension, prosecution, etc., shall harbor or conceal the other person. So a getaway driver, the state could have easily, I think, gotten a conviction under that. That's an F5. No presumption of
He
prison.
has to share the intent with the principal, correct?
He does, for
Okay.
complicity liability.
And so when we look at his mental state, his intent, when do we look at the intent? It would have to be before the act occurs,
So
during the act?
because burglary is complete the moment you enter a house or the moment you leave it, I would argue the snapshot of trying to determine mens rea purpose is the mens rea here, is the acts leading up to it or at the latest during,
But not when he sees him get into the car with the rifle.
because at that point it becomes accessory after the
Right.
fact obstructing.
So even if he sees the rifle and he's like, oh, my brother just stole that stuff from the house
Right.
and I'm going to drive him away,
Right, which some states.
your
criminal-
argument is that that's not enough. He
Not
did
enough.
not share the
And
principles.
only because Ohio law doesn't recognize that doctrine. In other states, that would be a crime that's prosecutable, whatever.
Thank you
Here-
thank you for your argument.
Okay,
I'm gonna
thank you. I'll
it.
reserve the remainder.
Yeah, Thank you.
Morning, Your Honors. Counsel. I anticipate being relatively brief here, but there are a couple of points I want to go over. The first one being venue. And if we look at first principles with regard to the law, venue, as this court noted in Sullivan, among other cases, you don't have to invoke talismanic language in order to determine whether there has been venue established. You just have to have enough evidence to create the reasonable inference that venue has been established. at the
Help us
crime.
understand the two-street situation.
The two-street situation.
Yeah, there's,
I can't
there's
account-
different street mentioned in the bill
Sure.
of particulars and before, and then they mention, there is a street mentioned here, and it says in Hamilton County, but it's not the same
Right.
street.
What I think is notable, that was Mr. O'Neill's testimony. I can't account for what happened with the two-street situation, whether that was a slip of the tongue on Mr. O'Neill's part, whether there was a stenographical error with the court reporter. The record is silent on that. But what I would note that is notable about Mr. O'Neill's testimony is he also says that he lives in Sailor Park in Hamilton County, Ohio. Notwithstanding the fact that there is no 675 Walnut Street in Sailor Park, he says in Sailor Park, which is commonly understood to be one of Cincinnati's 52 neighborhoods. And
Let
then
me
he
make sure I
reiterated-
understand this. Was he saying Sailor Park in conjunction to that address that he provided that's different than that in the bill of particulars? Or did he say Sailor Park independent of, outside of that?
No, I could not, no, not being able to account for what the genesis of that error in the record or in the testimony is, I can't account whether he was meant to say Home City Avenue in Sailor Park, but he was pretty emphatic that he lived in Sailor Park in the state of Ohio.
But he said he lived there, but what was the discussion of where the burglary occurred?
Well, I was actually just about to get to that, Your Honor. If you look at the Hingston case or the Sullivan case, you can look at the totality of the evidence to determine whether venue has been established. There doesn't have to be one witness who, lays it all out. You can look from the totality of the circumstances. And here, Mr. O'Neill said he lived in Sailor Park, and then you had Detective Ruberg, who watched this whole situation unfold, who said, I live across the street from the O'Neills in Sailor Park. And then going back to the Hingston case that I referenced, I mean, that was a case where there was less evidence of venue, and this court nonetheless found that venue was established. In that case, basically, as here, you had a bunch of investigating officers who said they were Cincinnati police officers, and then the drugs were analyzed at the Hamilton County Crime Lab, and that was the only evidence of venue, and this court said that was sufficient. But we have like in Hingston here, a bunch of Cincinnati police officers who said that they were investigating this case, including Detective Ruberg, who said that he lived across the street from the O'Neills in Sailor Park, when you had Mr. O'Neill saying that he lived in Sailor Park in Hamilton County, Ohio. So the state would certainly submit that venue has been established here. The only other thing I really wanted to address was this notion of the getaway driver and whether that can be evidence of complicity or whether that is accessory after the fact. And this case, or this court, is recently in 2022 in State versus Ward indicated that getaway driver can be complicity. There's ample case law on that.
And that is with regard to theft or with regard to a burglary?
That I can't get into. I think just as a general principle, with regards to any offense, being the getaway driver, whether it's a robbery, whether it's a theft, whether it's a burglary.
But you need more, right? I mean, more than just
driving away.
driving away.
Right, and here.
So you have to have some proof of his intent.
Sure, and I think you have that here, and I was going to get into that with regard to just weight and sufficiency generally. I mean, weight and sufficiency are pretty forgiving standards from our perspective, certainly. I mean, the standard for sufficiency is you construe everything in the state's favor and then determine whether any trier of fact could not have reached that conclusion. And then with weight, the trier of fact's conclusion has to be so off base that it creates a manifest injustice. And here was what the evidence was in this case. I mean, you've got first of all, you've got Mr. Lawson. He's in Sailor Park that morning. He talks to Mr. O'Neill. He knows that they are leaving.
Oh, wait, I mean, he was mowing lawns.
Right, well, he approaches
Okay.
Mr. O'Neill, offers to mow his lawn, and then Mr. O'Neill leaves, so he's aware that Mr. O'Neill is away from the house. And then you've got what Detective Ruberg, witnesses, and it's not just Mr. Lawson driving up and picking up his brother, it's him idling outside of this house on a side street that is really not very heavily trafficked, and then pulling up at the exact same moment while on the phone as his brother walks out of the house. I mean, that's a pretty happy coincidence there, and certainly, given the weight and sufficiency standard, one where I think a reasonable trier of fact could infer that he had knowledge of what his brother was up to, especially, the law on complicity says you can infer it from the circumstance, including companionship, presence, as well as his conduct. And this is pretty suspicious conduct here, pulling up on the side of the house at the exact same
I mean, I
moment.
will agree, it
Right.
is suspicious.
Sure.
But doesn't the law require more than us just speculating? I mean, usually cases have a little more to them.
Sure, and I would concede that this is, admittedly not the, well, I won't say not the strongest, but certainly it's a circumstantial case, right? You're inferring from the circumstances what happened here, but it's a pretty damning set of circumstances when you drive up to a house, when you're communicating with someone at the exact moment that they happen to be walking out of a house.
Well, you don't know who he's talking to.
We don't.
Right.
But the trier of fact was in the position to make that determination. I think they have leeway to make that determination. They can make one level of inferences from the facts and evidence.
But there are no facts there's no phone records, there's nothing. It's
Well,
just, you just assume that that's who he's talking to.
Well, I would disagree with.
Was the other guy on the phone?
The fact and evidence is that he was talking to somebody at that point.
Right.
And the timing is relatively suspicious. You can draw inferences from the fact. You can't do inference stacking, obviously, but you can draw inferences from the facts and evidence. And the facts and evidence here is he was communicating with somebody, and then.
Would you
know,
agree that there's a difference between speculation and an inference?
I do.
Okay.
And unless the court has anything else, I think I've said my piece here. So, thank you very much.
Just briefly.
Quickly, though, why is this evidence not enough? Why can't the jury infer that that's who he was talking to, his brother? Because he's on the phone, pulls up, brother comes out.
Sure. You have to have something more to infer from, and the reason I say that is I actually think that closely scrutinizing the facts, you have Ruberg saying that Alex was on the phone. It sounded like he was on the phone the whole time. Like you said, we don't know, no records were subpoenaed, which wouldn't have been an easy step, but regardless. Brandon then comes out of the house after Alex pulls up, double-fisted him, not on the phone. I think that right there dispels that he was on the phone with Alex. Alex still on the phone, Brandon not on the phone.
I did look at the testimony with regard to that.
Okay.
Because I thought that could be very significant. The way that I read a particular answer given by the neighbor officer,
Right.
it appeared to me as if he was no longer on the phone as his brother was exiting the house, based on the way that the officer responded. So if that were the case, argue your case based on that.
Okay. If Alex.
Could I add something?
Sure.
And when he pulls up, his brother's walking out with a rifle bag,
Right.
an ammunition bag, and a Glock in a case. So add that to the, your explanation.
And again, these facts support the accessory after the fact at most. We would argue that that still is too much of a level of speculation that Alex shared in Brandon's design to both the act of, in the cases that we cited, going through, throw out a few names, Spears, the Larry case, the Langford case. In these cases, because complicity liability is harder, you have to pull out some circumstantial evidence. They looked at the circumstances surrounding, even actually after the fact. And in some of those cases, for example, the person eventually convicted on complicity theory helped dispose of the evidence afterward, expressed a desire beforehand to rob or, steal from that person or place. So that was before. During, they expressed afterwards verbally their involvement as a getaway driver and were commended for being a great getaway driver. Things like that were present in Larry and Langford in this court's Spears decision that are not present here. So that's where we would distinguish between possibly it being suspicious, possibly looking bad, but still being more on the side with the pendulum swinging to speculation because we still don't have those records. We don't have enough connecting Alex. He could very well have been, even if he did talk to Brandon could have said, hey, how brothers talk to each other, dummy, you didn't pull up far enough, I'm down here. Not knowing, we don't even know if Alex stayed on site. If he more ran the business, because we know Brandon was cutting the grass in the beginning, maybe Alex did some running and came back to pick him up. We don't know, and that's the definition of speculative.
I mean, would you agree that on this matter, this case comes down to that fine line between speculation and circumstantial evidence?
I think that is a crux of this case, yes.
Okay.
So,
I am intrigued by the venue argument. I just want to give you an opportunity if there's anything you want to add with regard to venue.
Sure. Just one thing contrary to what Mr. Hill had argued, that just remember in Sullivan, the witness identifying roads was not enough. And we don't know if this Sailor Park, that way, is the only Sailor Park in the nation. I kind of bet it's not. That's not enough. If it was Las Vegas.
Can you clarify for me, when and how many times, and I don't mean like give me like the number,
Sure.
to the best that you can.
Yep.
Was Sailor Park discussed?
I want to say that Ruberg, let me see really quick. So O'Neill said Cincinnati, that wrong address. No, he did say Sailor Park, my bad. O'Neill said Sailor Park, and then Ruberg, when he got up, said he lived in Sailor Park across the street from the O'Neill's house. So those two witnesses, I believe, are the two that mentioned Sailor Park.
What's unclear to me is whether, when O'Neill gives that other address, is that when he says Sailor Park, or does he say Sailor Park independent of giving that other address? And it's okay if you don't know the answer because the record speaks for itself.
True that. In my notes, I may have succinctly put, I said he testified he lived at that address in Sailor Park, Hamilton County, Ohio. I don't know if that was one test, I
But
don't
it was,
recall.
you think it was
Close. I
tied to
think
the
it was
discussion
tied.
of that
Yes.
other address?
I think it
Not
was-
independent?
Right.
And again, the record will speak
And
for
then they
itself.
went on to speak about, but I would say that this town, this suburb, under the cases we cited in our control, especially the cases out of this court, when that other case with the Kroger, Vine Street, they gave a million details. Not enough. Hamilton County, it's that simple.
And then the neighbor officer said Sailor Park with regard to where he lived, and then
Yes.
saying he lived across the street.
Good.
Was there any other mentions that you can recall of?
I don't believe so, because they did call, there was a reference to an officer coming and taking a report. There was a 911 call referred to but not admitted, and I closely paid attention to those details, and the venue was not established.
So the 911 call is not admitted. What's interesting is also the map that was used
Right.
by the officer to facilitate the testimony
Right.
was not admitted,
Right,
which makes it very difficult to
Right.
break down the officer's testimony.
right. So, and all these other references, the investigating officer, we actually don't even know what police force he came from. It was all, a lot of blanks were left unanswered.
I thought we knew it was Cincinnati.
Eventually, when the detective, Trable, talks about investigating, he got the case to look into it. We do know he was part of Cincinnati, but the initial officer that came and took the report, we don't know. We don't know if this could have been transferred jurisdictions for all we know. Like, we don't know where it originated. And one last point, and I'll end, contrary to counsel, I think that this is largely based on sufficiency. We did throw in a manifest weight challenge because some of it was nitpicky credibility, but this is pretty much a sufficiency case. So with that, I would ask that the court reverse and discharge, either based on venue or sufficiency of the elements, or alternatively, reverse and grant a new trial. Thank you.
Thank you so much. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon. Daryl Swan et al. Versus Villas Condominium Unit Owners Association. Good morning, Attorney Jackson. How are you doing today?
Good, and yourself?
Good, good. Did you have a good Memorial Day weekend?
I did. How about you all?
It was good. It was good. I was surprised that it wasn't 95 degrees. I was pleasantly surprised.
Well, it would be in my home state of Florida.
Oh, I would have been minimally 95 degrees in your home state of Florida, for
Your
sure.
Honor, as a preliminary matter, I'd like to reserve approximately 7 minutes for rebuttal.
Okay, so that gives you 8 minutes, and you can start when you're ready.
May it please the court, opposing counsel, to the gallery. Your Honor, I don't expect that my remarks will be pretty lengthy. I think they will be pretty succinct. Your Honors, we're here today because we're arguing about on the issue of appeal with the first error of judgment. The first error is that there was no meeting of the minds of the contract down below at the trial court level.
If you can just speak up a little bit.
I was just going to say, if you need me to speak up a little bit, I'd be
Yes,
happy to
thank
do
you.
so. It's been a long time since I've been at this level, so I'm a little bit nervous, but I'm
It's
sure I'll
okay.
get through it in just a few minutes.
You're doing great.
Your Honor, our contention is that at the trial court level, that there was no meeting of the minds, there was no contract, that the parties did undertake a single settlement negotiation. Thereafter, they engaged in further negotiations that is in the record as well, and I believe the appellee's brief reflect that as well. Your Honor, the case law is clear that there's no binding contract. It's black letter law. It's Corbin on contracts. It's first year law school material. That there's no binding contract, or should be no binding contract found by the court unless first determining that there's a valid enforceable contract that existed at an evidentiary hearing. there was no evidentiary hearing that occurred at this level, Judge. There was basically, in my opinion, there was a rubber stamping of the defendant's position that there was an evidentiary hearing, and that there was a contract based on settlement discussions, a single settlement conference, and subsequent discussions that were held between the parties, basically around a provision of an indemnification clause. And the argument that I believe the opposing counsel will mention is that the settlement clause, the indemnification clause was not a material term to the contract, and that basically all the material terms of the contract were negotiated at the settlement conference itself. Our contention is that the indemnification clause is in fact a material term. And why is that? It's not, it wasn't just that it was a indemnification clause. This was at the heart of the disagreement between the two parties.
But I thought that I'm looking at the emails between the parties, and that was discussed between the parties. There was language suggested that I thought was incorporated, and there's an email on the 14th of December 2022 that looks like that the language was in fact incorporated, and they attached a clean copy and said, okay, we're good to go. So I thought that was hammered out in the emails.
Well, I think that was something that is a point of discussion, because the issue was that we had communications by and between attorneys, but it wasn't clear to me, it wasn't clear from the record that I could read that the clients for the plaintiffs had agreed to it.
Well, the attorney was negotiating on behalf of the clients, and my understanding is
Right.
that's enough.
Right, and we're not getting into apparent or actual authority to
Right, and there's no allegation that
There's no
attorney didn't
allegation
have
of
it.
that. And I think had there been an evidentiary hearing, a bona fide evidentiary hearing, I think that probably would have come out. But the fact that the trial judge allowed the plaintiff's counsel to withdraw prior to holding the hearing was plain error on his part, because there was no dialogue between the plaintiff's counsel at that point, because she had already been dismissed from the case. So the settlement hearing was basically an ex parte hearing with the defendants and the defendants' counsel and the judge. And there was a discussion between those parties as to what the settlement agreement was. And if you read the transcript of that settlement agreement, the settlement hearing, it was basically, well, we discussed some terms, some minor terms. I believe that language was referring to the indemnification clause, but overall we had an agreement that they agreed to. So if the agreement was not made regarding indemnification terms, my contention is that there was a material term that was never fully agreed to.
But what I don't understand, though, is why your clients and opposing counsel, your client's counsel, opposing counsel, informed the court, hey, we settled this case. Why didn't they say we are in the process of settling the case? But they made it sound like the case was settled, good to go, and the judge is like, okay, hammer out a written contract.
Right, it's important to understand, Judge, that at the time that the counsel notified the judge that the case had settled was prior to the discussions on the indemnification clause. So further negotiations ensued after that settlement agreement, and including an indemnification clause. Now, a cynical person might say, well, why isn't an indemnification clause just regular boilerplate language? Well, it really depends on the facts and the substance of that indemnification clause. So if you examine the indemnification clause that was proffered in this case, that would typically, I don't see where it's boilerplate language. I also don't see where it equally applies to both sides, as appellees argue in their brief. I also don't see where there's a benefit to plaintiffs for signing that indemnification clause, because basically what's happening in that instance is that you're binding potential devisees, you're binding potential legatees. There's not even a definition of what an owner is. So let's say someone purchases a property, they're bound to an agreement that they didn't necessarily negotiate. Let's say if someone dies and there's a survivor, that person's bound to that agreement. So these persons who succeed, the current owners who are signing this agreement, have no say-so, no negotiation with that agreement. So they're being bound potentially to what? Into perpetuity.
Okay.
Does that answer your question?
Somewhat.
I hope so.
I have a question. It's going to
Yeah.
sound sort of a little bit weird, but just play along. Okay. The condo association documents, was that part of the record in this case?
The condo association's documents?
Yeah, yeah.
I believe they were added to the record later on, but I'm not 100% sure of that.
And the reason I ask is because sometimes there's provisions therein that govern these sorts of things.
And-
As to when there's lawsuits between the unit owners, the
Right.
association and so on.
And Justice Krause, as a contextual matter also, these plaintiffs they're all of retired age. They're in their 70s and 80s, so they heavily relied on their counsel to represent them. So they were in a position where they probably weren't always in their attorney's office or maybe, I won't say as attentive to the cases as they needed to be, but they heavily relied on their attorney to negotiate on their behalf. And the fact that there was some type of proffer from opposing counsel regarding the initial indemnification clause, and then apparently an offer from the plaintiff's counsel to revise the indemnification clause, I think the plaintiffs were put in a position where they had an untenable position at that point, because I think they were in a position where they felt like maybe they were forced to be doing something that they didn't do. But I think the more important point there is that appellees contend that all of the material terms were negotiated at the settlement conference, and that can't be true if the court finds that material terms in the indemnification clause were in fact material terms that were not agreed to necessarily, even if the court says that the plaintiff's counsel did agree to it. The fact that there was a repudiation or attempted repudiation by plaintiffs themselves that we didn't want to agree to it, that the appellee's counsel knew about at that time, and apparently the trial judge knew about that at that time, I think is instructive as well.
Is there any case law? Well, first of all, are you saying that the indemnification is a material term as a matter of law or with regard to this case?
I think it could be both. I think if as a matter of course, I think in general contract law, that if it's a material term as a matter of law, that states, Corbin on
Sure, if
contract
it's a matter
states
of
that-
law, then that makes it really simple
Right.
from our perspective. Do you have any case that you can refer us to that would support that an indemnification clause is a material term?
I don't have that with me today, Your Honor, but that's something I could happily supplement later on if I could do that. But what I can tell the court is that in the Rowley case, that the Rowley case and some of the holding of that case, it says if the meanings of the terms of a settlement agreement are disputed, or whether there's a dispute that contests the existence of the settlement agreement, the trial court must conduct an evidentiary hearing prior to entering a judgment. And that clearly was not done in this case. As I mentioned before, there was a settlement hearing wherein the trial judge allowed the prior counsel for plaintiffs to withdraw. So I think the more prudent question that I had in reviewing the case was that, the trial court, why couldn't the trial court have reviewed the apparent authority of the withdrawing attorney at that hearing prior to allowing that attorney to withdraw? In other words, engage in a soliloquy about what your clients understood, what your clients agreed to. Did they agree to this a contract?
What evidence, though, when the parties notified the court that there's a settlement that was reached, what evidence is in the record that they did not intend to form a contract until a written agreement was actually signed? Is there anything that they indicated that the settlement is contingent on a signed agreement?
Well, I think if the court reviews a record, I think there was a mandate from the trial judge that a written agreement be
Right.
agreed to by the parties.
But did they indicate that, okay, well, we're going to hammer out the terms and it's, we have a tentative settlement here, but that's what I'm trying to understand.
Right, and I think that would be a fair proposition to make, except that after the parties informed the court that we have an agreement, then the appellees come back with the retort that we want this indemnification clause as a part of the contract. So I think at that point, the trial court wasn't aware that there was an indemnification clause that was a part of the settlement agreement.
And that's what blew everything
It
up.
blew everything up, in my opinion. So at that point, there was no contract.
Let me make sure that I understand, and I might have misunderstood what you just said, so I want to make sure.
Absolutely.
During the settlement discussion, there was no conversation about indemnification? Is that what you're saying?
That's exactly what we're saying, Judge.
Okay.
It's pretty clear.
Then after terms had come to an agreement, then indemnification gets brought up?
That's correct, Judge.
Okay.
If the court
So what you're
refers-
saying, so I don't know if it's an issue of material terms, or is it an issue of that the settlement was changed, or was sought to be changed, and that's what blew it up?
Well, I think the court can take it both ways. I think if the court looks at the appellee brief on page 9, the appellee, it's from the transcript. Thereafter, I, along with opposing counsel, this is during the settlement, the hearing on the settlement agreement, to enforce the settlement agreement, had some exchanges back and forth regarding some minor terms. Now, at that point, there's no opposing counsel in the courtroom to argue what those minor terms would be. So the court's basically, at that point, taking the word for the defense counsel that the terms were not material terms. It's our contention is that the.
So what you're saying, I think I'm getting your argument, and let me see, okay?
Yes.
So what you're saying is that there should have been an evidentiary hearing held to determine indemnification. Was that discussed, was that not discussed? Whether the invocation of it thereafter was changing, you know, the settlement as it was discussed.
That is correct, Judge. That's
That's what
correct.
you're saying, right?
Right. I'm saying, that in theory, there wasn't an evidentiary hearing that was held, and my contention is that it wasn't a bona fide hearing. Again, you have the appellant's counsel present and available to answer questions about what the agreement was.
So what you're basically also saying is that there were issues of fact that needed to be determined in order for the court to make its decision on whether it was an enforceable agreement, and there wasn't a full and meaningful opportunity because there was no hearing to present those issues of fact.
That's absolutely correct, Judge.
Okay.
But would you agree that the emails that we do have in the record demonstrate that both counsel negotiated this indemnification agreement, hammered it out, and then the only thing that was left to do is for your clients to sign the agreement?
What you say is true.
Okay.
However, again, and I know it's not a part of the record, but given.
We can't consider it then.
And given, just as a contextual thing, given the ages and fragility of the clients, I don't know that they knew. I don't know that they were.
Yeah, but that's the problem. And what we have in the record are emails where
understand.
counsel's going back and forth on the indemnification agreement, negotiating language, saying this is what my clients want. That language is put in there, and then the only issue that was left was for them to sign.
Right, well, you can't say that all of the material terms were decided at the settlement conference, but then that there's this indemnification clause that we discussed after
Right,
the
no.
settlement agreement. You follow where I'm going?
No, I completely follow where you're going, but I feel like everything was ultimately pretty much hammered out except for the signature part between the lawyers, and there's no indication that your clients, and I know it wasn't you, your client's attorney didn't have the authority to negotiate on their behalf.
Sure. Well, wouldn't it have been just as easier during the settlement, the hearing on the motion to enforce a settlement agreement, to ask their attorney what type of dialogue or what type of conversation she had with her clients at that point to make sure that the court was aware that the parties themselves had been informed and had given their informed consent to what the indemnification clause was, before allowing her to withdraw? I don't think there was a time issue. I think if you look at the transcript of the hearing itself, the court decided on its own, sua sponte, to hold a hearing on the motion to withdraw prior to holding a hearing on the motion to enforce a settlement agreement. What if it was reversed? What if it was reversed and you hold a hearing on the motion to enforce a settlement? Ask the attorney at that point, what type of discussions did you have with your clients about this indemnification clause that was discussed after the settlement agreement? Did they fully understand it? You're talking about 6 elderly clients. Was the conversation had with all of them at one time? Was it held with them individually? How did they understand it? Do they agree to it? Do they understand the long-term, perhaps financial ramifications of that? Because when you're dealing with people who are at that age, I'm sure that having some type of knowledge about the financial implications of signing a clause like that will be important to their legacy and maybe to their, estate planning. That was never done. I believe that the trial court erred in not holding a proper bona fide hearing on that point. So, to say it's boilerplate, I think is disingenuous, because you can have different types of indemnification clauses that can be deemed as being boilerplate. However, I don't think this is a typical boilerplate type of clause. It's not, how is it?
Thank you for your argument.
Okay, thank you, Judge.
I still have your time reserved. Good morning.
Good morning. May it please the court.
How are you doing this morning?
Very well, thank you. This case is remarkably straightforward. The parties had a settlement in September 2022. It was an oral agreement. And then when it came time, months later, to put their signatures on the written page, all of a sudden they got cold feet, and now they want to pull out. But the law doesn't allow them to do that at that late date. And there's 3 reasons. First, the oral agreement was a settlement agreement. It's enforceable under the law. You don't need a writing. The fact is that a written agreement was not a material term of the agreement. And so the lack of a signed written agreement does not preclude enforceability of the oral agreement. That's point number 2. And point number 3 is that all of the excuses that you've now heard that plaintiffs have belatedly offered for why they want to pull out of the settlement agreement, none of those excuses
All the
invalidate
reasons.
enforceability.
All the
Exactly.
reasons they provided, not excuses, but
I'm sorry, reasons. So first to the first point, there was a settlement agreement in September 2022. The parties, after much discovery and motion practice, decided that it was prudent and advisable to meet in person and to try to hammer out the terms of the deal and to talk. And that's exactly what they did. There was an in-person settlement conference. The parties met with their attorneys for several hours and went over the terms and hammered out the terms of their ultimate agreement. Now, as an aside, this is sort of the case that really did need to settle, because the main complaint, the main allegations of the complaint was plaintiffs were unhappy with the board's operations and management style. And so, they were seeking various forms of relief, but money damages wasn't really the sort of relief that can remedy that sort of, those sorts of complaints, right? So the parties decided after several hours, okay, we've reached a deal. And the material terms of that agreement were conditions surrounding the timing, the frequency, the topics, and the conduct of board meetings. That was what was really important to the plaintiffs. And that was the subject of the bilateral negotiations. And there were compromises on both sides, and the parties struck a deal. So that is the oral agreement. Now, there's no evidence, and Mr. Jackson has not pointed to you to any evidence this morning, that a written agreement was a condition of the settlement agreement. There's no evidence in the record of that fact.
the heart of his, as I understood, the heart of his argument was that after there was a meeting of the minds, and I'm adding words to what he said, that then an indemnification was presented, okay? And of course, indemnification is now binding individual, oftentimes well past even ownership of the property, okay? So an indemnification was then presented, and in essence, what he's saying is that that was a material term that should have been negotiated to begin with, not presented after there was a meeting of the minds on all of these terms.
And perhaps if Mr. Jackson had represented the plaintiffs at that time, this would have come out differently, but he didn't. The plaintiffs were represented by their predecessor counsel. And she looked at this indemnification provision that defense counsel proposed. She said, I don't like it. I'm going to add some more language here that is more favorable to my clients. And there was some back and forth discussion about that. And ultimately, she's like, okay, I'm fine.
So what you're saying is that then there was another meeting of the minds after that with regard to the indemnification?
There, regardless of whether you consider the indemnity provision material, it wasn't material, but regardless, there was ultimately a meeting an agreement as to the term. If you look at the settlement agreement, the written settlement agreement that is in the record, the language that plaintiff's predecessor counsel proposed is in there. So there's an agreement, there's a meeting of the minds, it was agreed upon. So whether or not it's material at this point just doesn't matter.
So if we didn't have that in the record and the attorneys couldn't agree on the indemnification language, then what?
If they hadn't agreed to the
Would you still be able to enforce the settlement?
I think I think it depends on whether that indemnity provision was material. And if it was material, it surely would have been discussed at the settlement conference, and it wasn't. I mean, the reality is this is just practice, right? Parties agree to an oral settlement, and then later, when they memorialize the agreement in writing, there are always additional terms that go into the writing. It doesn't make them material, right? It's just because that's the nature of a written agreement. There's nothing to indicate at the outset that was...
Why wouldn't this be material?
It wasn't material to the parties at the time. I don't know why. It just wasn't.
Yeah, but it seems like that's the big sticking point that blew this whole thing up. So it sounds like it wasn't discussed at all when they reached the settlement, and then all of a sudden, your side throws in this indemnification language that blew up the whole thing.
But it didn't blow up the whole thing because it was ultimately agreed to. The parties discussed a bunch of stuff. The parties discussed, non-material terms, non-material revisions. There were red lines. That's just the nature of how it goes when you memorialize a written.
Well, they refused to sign because of this.
But we don't know actually why they refused to sign, because when predecessor counsel emailed defense counsel, it wasn't me personally, but defense counsel, and said, hey, my clients aren't going to sign, they're going to voluntarily dismiss or voluntarily withdraw and refile. There was no explanation given. We don't know why they decided to pull out. They didn't say because my attorney didn't have authority. They didn't say because I don't like this indemnity provision. They didn't say because I got cold feet.
Doesn't that kind of go to Mr. Jackson's argument that there should have been evidentiary hearing with regard to the motion to enforce the settlement?
Well, I'll point out that they didn't ask for an evidentiary hearing. Okay. So if Mr. Jackson is saying the trial court ought to have...
So that was waived?
So, yeah, it's waived. Mm-hmm. And to the extent the argument is, well, the trial judge should have sua sponte ordered an evidentiary hearing to probe the attorney-client relationship. Well, there was no reason to do that. The plaintiffs aren't asking for it. We don't know the reasons why they pulled out of the settlement agreement, and nobody's questioning the attorney-client relationship. I mean, why would the trial judge do that, right? So because the writing was not a material term of the settlement, the failure of the plaintiffs to sign it has no impact on its enforceability. And in fact, it was the trial judge who said, hey, you need to put this in writing, and I'm setting a date certain for you to do that by, and then after that, I'm going to enter a final judgment. And then the judge reflected his understanding through his clerk to the counsel, said this judge's understanding, this case has settled, right? Didn't say, the judge wasn't under the impression the parties are on the way to settling, the parties are still discussing settlement. It has settled. And if that was an incorrect impression, certainly it was incumbent upon plaintiff's counsel at the time to correct that impression. She didn't, because everyone understood that there was a settlement. So because the writing at that point was purely a ministerial act, it has zero impact on enforceability. And then the third point is these belated reasons that plaintiffs offered after the fact in these affidavits after the enforcement order had been entered. None of these reasons go to enforceability of the settlement agreement. None warrant not enforcing the settlement agreement. So the first reason that the plaintiffs give is, well, I didn't consent to anything. I didn't personally consent to anything. But Judge Krause, as you pointed out, they were represented by counsel. She consented on their behalf. That is binding on the plaintiffs. And there's, of course, no evidence in the record to suggest that she didn't have that authority. Number two reason that the plaintiffs give is that they said, well, we had no notice of the enforcement hearing. Well, their attorney did, right, because she showed up for it. So at that point, they're still represented by counsel. They are not entitled to separate personal notice of the hearing. The notice was given through counsel. The number 3 reason that they said, well, we weren't represented at the hearing. Well, because their attorney had withdrawn at that point, and the motion to enforce hearing was held immediately after that. Well, the reality is that plaintiffs knew their counsel was withdrawing and was not going to represent them any further. And they admit this on page 7 of their brief. They said, hey, we knew she was withdrawing, but geez, we thought we could voluntarily dismiss the case at that point and refile. But that's a wrong belief. That's not chargeable to the defense. That's not a reason to invalidate the settlement agreement at this late date. And finally, the plaintiffs say, well, we didn't get proper service of the enforcement order. They haven't posited what was improper about service of the enforcement order. The enforcement order says for defense counsel to serve the plaintiffs by regular mail, and that the plaintiffs have 10 days to object. Well, the plaintiffs got the enforcement order within 10 days. It didn't say you have to receive it within a time certain. The plaintiffs admit they received it within the 10 days on day 8, and they still had time to object. But for some reason, they opted not to do so and not to seek an extension of time. Again, that is not a reason for now unraveling an otherwise enforceable settlement agreement. So none of the reasons that plaintiffs have posited here, either today or in their brief, justifies invalidating the oral agreement that the parties had at the very outset. If the plaintiffs got cold feet, that's not a good enough reason under the law. The trial judge correctly recognized and understood that and enforced the settlement agreement. And for these reasons, we ask this court to affirm the judgment. Thank you.
Thank you.
Your Honor, I'll be very brief. In order for the court to buy the argument that the indemnification clause was not material, the court has to believe that and understand that the indemnification clause, as argued in the appellee brief, is immaterial to the contract itself that was negotiated. Counsel briefly stated on the record that all of the material terms important to the appellants were agreed upon at the settlement conference. We agree with that. The argument that we have and the problem that we have is that the indemnification clause was a material term that affected the entirety of the agreement that was agreed to at the settlement agreement. And therefore, as Justice correctly pointed out, it blew up the whole agreement.
The counsel made the point that I thought was interesting. When you read the email exchanges, it's not clear that that is what blew everything up. We have the indemnification clause was negotiated. Your side, your predecessor negotiated certain terms that were actually included. And then all of a sudden, your clients wouldn't sign. And there's no indication in here about why.
Well, if there had been a bona fide evidentiary hearing on the matter, that matter might have been more fleshed out at that hearing. And it's our contention that there was not a bona fide evidentiary hearing because the trial judge dismissed and allowed the plaintiff's counsel to withdraw.
So you're saying that there should have been a request for or that the court should have sua sponte?
No, it's a mandate from the Supreme Court that
Okay.
if there's issues about whether there's existence of a settlement agreement or there's some kind of confrontation or disagreement about the terms of an agreement.
You don't have to,
You don't have
nobody
to-
has to ask for an
It's a mandate.
evidentiary hearing.
Must, right, and that's correct. So the issue becomes, was this a bona fide evidentiary hearing? I contend that it was not. An ex parte hearing can certainly not be seen as something that can be an evidentiary hearing because only one party is arguing. And furthermore, if you take the very bare bones transcript of the hearing itself, that was just simply, well, tell us why this should be enforced. There was no soliloquy about, well, what was the agreement? And how did you come to that agreement? Did you have discussions with the opposing counsel about it? Did the opposing counsel explain to you that she explained the agreement to her clients? When was that? Was there email? Were there telephone calls? Were there text messages? In all the case law that's cited by the appellees, there was always representation at those evidentiary hearings by both sides. There was no ex parte hearing. My contention is not an evidentiary hearing at all. It was merely to rubber stamp what the defense counsel had stated that there was already an agreement to. So, yes, are there some issues with prior counsel's representation of the plaintiffs? Yes, I agree with that, but that's not why I'm here. I'm here to point out that in the appellee's brief, it stated verbatim that at the time that the hearing was set, plaintiffs had representation, and that's true. But at the time of the hearing itself, because the trial judge allowed the motion to withdraw to go forward with prior counsel, at that point, there was no representation. So why not continue the hearing? Why not give plaintiffs an opportunity to defend themselves? And I think contextually, the motion to enforce settlement was done on December 22nd, 2022. The motion to withdraw as counsel was filed 5 days later on December 27, 2022. The hearing on both motions was on the 23rd of January. The court grants the motion to enforce a settlement agreement the very next day on January 24th, but waits until February 6, 2023 to grant the motion to withdraw as counsel. Also, one just ancillary point that I think I just wanted to touch on was that the appellees made a couple of points in their brief about, well, the reason why the objection at the trial court level was properly heard, and one reason why it wasn't well taken is that one of the parties didn't join on with the objection. And I'm sure the court read that. It's because she passed away. She's dead, so she couldn't possibly have joined into the objection because she was dead. And her family has reached out, and they were very upset about that. Just wanted to mention that, just because.
Understood.
The counsel mentioned that the material terms, she said it herself, that the timing, frequency, and the contact with the board members were the material terms that were discussed. The court has to find that the indemnification clause was not a material term that was properly negotiated on. Now, Justice Krause mentioned that, well, it was negotiated, it was back and forth. Well, in the hearing on the motion to enforce a settlement agreement, that should have been discussed. That's our contention, and it was plain error to allow the attorney to withdraw and not even have a discussion on whether or not there was an agreement on the terms of the indemnification clause.
Thank you.
Thank you very much.
Thank you so much. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Karen, if you give me a second just to gather my stuff before you. Just give me a second. Are you okay? Okay, yeah. We're good to go.